And welcome to Unit Chambers podcast, Family Law and More. My name is Amjad, Kadhim, consultant barrister at Unit Chambers, and I'm joined today by Lisa Edmunds, our CEO and senior consultant barrister at Unit Chambers, and Claudia Saxton, our consultant barrister as well at Chambers. Today, our podcast is going to be focusing on finding of fact hearings and just having a look at where we're at right now, really, having an opportunity for us as barristers to speak about our own personal experiences of fact findings, certainly in terms of since big cases that have taken place in the family law sphere, such as Re HN and also the President's guidance on the law of fact-finding hearings. We hope you'll enjoy it. And I think I'll just start off by welcoming you both. How are you both?
Hi. Good, thank you.
Amjad, thank you.
Good. I'll probably start off myself, actually, in terms of finding of fact hearings. And we had this situation where we had a case called Re HN, which came out to the Court of Appeal in 2021. And in that, I wouldn't say that really that case was one that reinvented the wheel, so to speak, but it provided some much needed clarity for practitioners, for judges to grapple with what are the key issues in cases and just not get drowned out by the noise of allegations being made between parents, especially when Practice Direction 12J is engaged. I'd probably say, and if I could just start off with the topic of Scots schedules, because you'll have seen in the case, the President and certainly the Court of Appeal had given an indication that Scots schedules might not be the most accurate or best way of going about deciding allegations of domestic abuse, particularly in the form of coercive control. And the rationale behind that is that when you have a Scots schedule, which is very sort of binary in terms of just setting out specific dates, times, events, and it's a case of whether that gets proved on a balance of probabilities or it doesn't. The courts thought that actually that might not be the most helpful way, because actually when you're dealing with relationships that feature coercive control, they tend to be far more subtle behaviours, if that's probably the best way of putting it. And it may not then give actually the court the best way to look at a relationship holistically in terms of what happened in that. Now, in terms of reforms or suggested way forwards, I can't remember off the top of my head whether it was Re HN or in the President's guidance, but certainly the Court of Appeal had talked about maybe presenting alternative documents. One of them might have been something that's akin to a threshold document that you can get in public law proceedings. And actually, probably on the thought of it, seems like a fairly good idea. I mean, my sort of view, just off the bat, is that I feel it's still quite a similar document to a schedule of allegations, and quite properly, because the court needs to have a bit of a steer as to what it's going to be deciding in terms of hearing evidence from parents. But I don't know about either of you, but I'm not really seen that much of a departure from what we're still doing, which is schedule of allegations. And I don't think I've even had a case where I've done a fact finding where the judge has just used no schedule whatsoever and has just listened to the narrative, or considered narrative statements from parents and just listened to the parents themselves.
No, I've not had any experience. And I think maybe through that lens, not much has changed other than dropping the word Scot, and it may be that you're directed to file and serve a schedule of allegations. But as you say, that sort of tabular format still provides a useful checklist for the judge at the hearing to cross-reference the evidence as against the original allegation or allegations pleaded. I had a case recently where the judge did use that as a binary document. The schedule did contain allegations of controlling and coercive behaviour, so the more nuanced allegations that we deal with, but it also contained sort of binary allegations. So for example, on X date, he did assault the mother, that type. And the judge during submissions identified that the other side hadn't actually put those allegations to my client and just struck them out. So in that sense, it proved useful because the judge was just working through that document saying yes, no, no, yes, as part of retaining some control and structure over the closing submissions. I don't know if you had much experience, Claudia, any change?
I think it's still, a schedule is still being used, but I think, like you've said, after REHN, it's clear that that's perhaps not the best method to use, especially for controlling and coercive behaviour, because as you've said, it's not necessarily this date and time, and clients can't always remember. It's a pattern of behaviour, but I still don't know what's the perfect way to plead that, whether, like you say, that's more of a threshold document, or whether that would encompass everything in enough detail for that allegation to be pleaded. I don't know.
Yeah, I mean, I don't think it's necessarily a prejudicial thing to a case actually nowadays, because I think certainly within the past 5 years or so, and with cases such as F&M, I think that the concept of coercive control and really getting a very, very deep understanding of what those relationships have been has been featured quite predominantly now in family courts. I think judges themselves are very, very well versed with the concept of coercive control, how it feeds into the day-to-day workings of a relationship. And ultimately, judges aren't bound by the schedule of allegations that they present, you know, at the end of the day. You might have a form of direction in terms of the case, what are you actually deciding on a fact-finding hearing? But the judges are very, very likely to be hearing oral evidence from parents that go above and beyond the allegations themselves. Parents will talk about other aspects of their relationships or certain events that might happen in the course of the evidence. And like I say, judges aren't necessarily bound to follow the schedules. They may even produce or make their own findings above and beyond what's set out in a schedule. Or even if you have a schedule of allegations that may not be focusing so much on coercive control, might be focusing on other aspects and stuff as well. You know, judges can still make findings based on other things like coercive control. So
I had another case where on the schedule it said over X period there was coercive and controlling behaviour, and then it simply referenced the judge to the applicant's statement paragraphs, I don't know, 8 to 16. So again, as a one-pager, almost sort of getting that helicopter view as to what's going on, the schedule served its purpose, but it didn't deprive then the applicant of being able to build that pattern of behaviour to try and explain why there was that overarching allegation being pleaded. I think from a practitioner's point of view, it still then meant you had to go deep into the papers. And I think it's a fine line how far you go with putting your case, because if you were then just sort of putting your case from the perspective of the schedule, no, you know, there wasn't coercive and controlling behaviour in the relationship, was there, sort of quote unquote, versus going through those 8 paragraphs where there is sort of detail about specific episodes. Do you have to go through that exercise in order to have properly sort of executed your responsibility to your client? Because if you sort of just took 3 or 4 of the allegations and challenged those by example to that overarching allegation, and you've not dealt with the balance, is there the risk that the judge could take the balance, you know, the 4 that you've not dealt with, and allow those to underpin that overarching claim on the schedule? So I'm not convinced it sort of necessarily deflects from proper process. But I think in terms of just being able to have a check-in on the case at a high level, sort of macro rather than the micro level, it definitely, I think, is still fit for purpose. That's been my experience anyway.
How do you find fact findings have gone personally in terms of your personal experience since REHN?
I still think there is some inefficiency and ineffectiveness getting to the point of a fact find. I still think it takes too long to get to that point, especially when children aren't then maintaining a relationship with one of their parents. But I think in terms of process, I don't think much has changed really if you get to an effective hearing. I don't know, Claudia, what's been your experience?
I've had a few facts find recently which have settled, and it's actually been the court and the judge which has been encouraging the parties to file statements of admissions or...
At the point of fact find or before?
Before,
right.
But also then getting to the fact find where there's clear evidence of, videos, for example, showing the allegation. I think rather than having those parties be questioned, and especially if they're agreeing that there will be contact afterwards, what help is it really going to have polarising these parties against each other when the evidence is quite obvious? Or alternatively, if they are quite close, or I've had a case recently where the parties accepted, actually, I don't really want to pursue the allegations anymore, I don't think it's going to help. When it's, like you've said, it's not necessarily a straight process of getting to a fact find, and sometimes if it's years down the line, their positions can change from at the start, and it's not necessarily what's right anymore for the child.
Yeah.
So cases resolving at that stage, is that at a FEDRA, or is the FEDRA directing statements to come in, and then there's actually another hearing that falls between a FEDRA and a listing for a fact find?
Exactly, it was after a FEDRA and a directions then for the fact find, which once there was more evidence and it's clear there's a video showing this allegation, for example, let's think about, do you want to admit something here?
So it's almost like an IRH or a DRA on the schedule, which I think is really good. It's positive to hear that is happening, because it obviously reduces the risk of delay a case being listed, where then, we've all been there morning of day one and the case collapses for whatever reason. And you think, actually, if someone had done the deep dive months ago, all of that could have been avoided. So it's interesting to hear that judges are, I suppose, being a bit more proactive. Have judges then reserved those cases to themselves to make sure they've got that continuity?
Yeah, exactly.
That's good.
Yeah. I think, like I say, probably the biggest area of reform, or the biggest form of improvement, is the time it takes from the application that's being made to the moment when there's a decision about a fact-finding hearing.
Yeah.
Because I think the problem is, certainly with FEDRAs, I could go on a whole tirade about FEDRAs myself, but you're always going to get that classic issue of the applications made. People have made allegations in the C1A, they've made allegations in the safeguarding letter, and even then you reach the point of a FEDRA and the judge is like, well, I think I need to see statements of evidence, and then to come back in what probably is like 8 to 10 weeks, which is already a big chunk of time, that might be a case between a parent not seeing their child. I wonder whether there could be some sort of reform in terms of the whole gatekeeping process, to have a situation whereby when you have the FEDRA, that you will have everything that they want to say. Obviously, you can't let it go into reams and reams, but I don't know, a 6-page statement or something like that, setting out, I think these allegations are relevant to the making of an order. This are the reasons why, and these are the specific allegations. So the judge can actually make a decision there and then in terms of the FEDRA as to whether to go ahead with that.
I agree. I think that would be a far more effective and efficient way of case management. And I think you can definitely control the parameters of what you're trying to achieve at that juncture. So whether it's, capping the length of statements, maybe not permitting exhibits, but a list of proposed exhibits that, either side may wish to reduce. And also, if you sort of have a 2-step process, if the judge is going to direct a fact find, then you're sort of halfway there in terms of evidence, so you're ready to list. But it seems to me there could be a conversation if the judge says no to a fact find, then because the evidence to date has only been focused on allegations, that can largely then be removed from the bundle, and there's a reset that's then focused on welfare arrangements for the children. I think that's one of my bugbears at the moment a little bit, about how the papers can become contaminated with references to allegations that are then not permitted to be pursued. But if you then go off and get a Section 7 report, for example, the CAFCAS officer is still reading that information, potentially when the respondent hasn't had an opportunity to formally respond in the same way. Because the judge has said this isn't going to be relevant, so that's a proper consideration, and from the respondent's side a positive sort of direction of travel. but you're then still, on a subconscious basis, allowing an assessor to read only half of the story, so to speak. And I've had 2 cases recently where the parent A has put forward allegations. The judge has said, I'm not going to entertain that. CAFCAS have then filed, and because parent A has said within the paperwork that certain things happened, and CAFCAS have then sort of deployed their toolkits, their checklists, they're making recommendations based on the fact that that parent has been a victim. And so you just sort of go circular, and it's all become a contaminated process.
Yeah.
So I don't know whether that is the answer, but I definitely think it's worth a conversation about front loading the evidence around the allegations, make a halfway sort of half-time decision, and it either sticks, the evidence either sticks and moves forward with the case, or it's taken out and sort of archived.
Yeah.
No, I agree. And I think actually even then, in terms of sometimes when you have a situation where the judge decides against a fact find, but you get a Section 7 report, I think one of the most frustrating experiences I can imagine for a parent is for that Section 7 inquiry to progress, the investigation's completed, the report's prepared, and the CAFCAS officer says, I need to make a recommendation for a finding of fact hearing.
Yeah.
And I think sometimes the reason why you kind of get to those scenarios, and the reason why there might be a bit of a disconnect, is because I don't see it all the time, the question of fact finding grappled at a FEDRA, and that clear recordings are put in the order to say the fact finding hearing exercise has been considered, the court is not going to embark on the fact finding reason for these following reasons.
But you meant to.
You meant to. It's in the procedure
yeah.
rules. But I actually don't, I think for the vast majority of the private law cases that I do, I rarely find that that's addressed in adequate detail.
Yeah, I don't think it goes far enough when you do see it recorded, because it will just be no to a fact find, but it doesn't deal with the allegations.
It just says it's neither necessary nor proportionate.
But the allegations haven't been grappled with.
Yeah.
Because you can obviously have a judge determine quite properly that those allegations may be relevant, but to be looked at within a sort of composite listing when you've got that welfare analysis and you can do that matching process. But where it's just left unsaid, I don't think that helps anyone, because everyone comes to the sort of analysis from potentially different perspectives with different considerations.
Yeah.
And I think I think certainly in terms of how ReHN has kind of framed the question of a fact-finding exercise and how you deal with it, the critical principle is, are the allegations relevant to the making of an order?
Yeah.
And sometimes I think when you're dealing with those recitals, I don't think sometimes that they address that question fully, because all you'll get is just a line that just says it's neither necessary nor proportionate. But I think orders need to be far more detailed in explaining it's neither necessary nor proportionate for these reasons.
Yes.
Reason A, this allegation would not be relevant to the making of an order because of X, Y, and Z. And I think that needs to be spelled out, because the consequences, the delay that happen when you get that. I mean, you have a case where parents might be waiting 12 to 16 weeks for resolution in their case from a Section 7 report. To get that recommendation for a fact-finding hearing when it's already been dealt with in the court must be one of the most infuriating things ever, because if you're then going to get an addendum report from CAFCAS, that's probably going to set you back another 8 to 10 weeks or whatnot, really, just because of their workload.
And like you say, in the meantime, the parent with the allegations against them, if they're not having contact in that time, I think that is really harmful, especially for their case. If they've not been seeing the child in that time, they don't have any evidence about how the child's presenting with them.
I think as well, just I'm going to go on a different topic, but I want to put a question to you both, is that because you have a situation where the key message in terms of the exercise you have to embark on necessity and proportionality of fact-finding hearing is the relevance to the making of an order, have you both noticed any kind of effect on how courts now approach certain forms of allegations? Because I think actually one of the big ones that I rarely now see litigated is financial control, because that kind of financial abuse and stuff like that. Because I think it's quite difficult sometimes to frame an argument. And I think it's probably the trickiest allegation to frame an argument as to how it's relevant to the making of a child arrangements order. When you have a situation where parents are now separated, they lead their own lives, they have their own financial responsibilities, not jointly together. And what's your sort of thoughts about things like that?
Yeah, I would say similar to you. I've not really seen it gain any traction. And when it has been a live issue in a case, I'm not too sure how or why it's been allowed to get to that point. My most recent example would be where the complaining parent was saying there was financial abuse because of the way in which they took out their mortgage 20 years ago, and because of who paid for the decking that went in at that property. And, you know, without sounding brutally unkind, it was like, well, who cares, in the sense of what has that now got to do with how your children spend time with one another? But again, it had been permitted to be part of the fact find, so we had to sort of go through that exercise. I think in reality, the allegation of financial conduct will sit on a par really with how conduct in financial remedy cases is dealt with. So, you know, you're looking really for something that you go, whoa, that's a standout feature. And where maybe a parent's independence has been particularly handicapped because of the way in which the money has been managed. But I certainly haven't seen it on that scale, in that sort of latter scenario.
No. Or for me, it's more been, like you were saying before, about examples of controlling and coercive behaviour. It's come under that heading as an example of that, rather than
It's
an
kind of
allegation
like you're trying to show,
isn't it?
yeah.
I mean, it's a bit of a backdoor way.
Yeah.
It kind of is. I think the way the arguments now are framed is it's like when you're bringing financial abuse into a picture of coercive and controlling behaviour, you're trying to prove or show that financial control is one of many features that exists in terms of how this person operates towards me and how it operates towards us as the family. So I find that's the way that it kind of gets framed in respect of that.
No, I think that's valid. But whether it's still relevant,
Yeah, I always find
whichever
it's so hard.
subheading it might fall under,
Yeah.
I'm not convinced.
I think it's a tricky thing to argue in terms of relevance, really. Do either of you have any thoughts about what should change with fact findings moving forward?
I don't think that the concept and the need for them should be reconsidered. I think it's just about how you get there. You know, if I was sort of trying to drive change, it would be being able to allocate court time once all the evidence is in, and sort of doing that deep dive analysis as to whether or not the allegations are relevant, looking at evidential output. So again, sort of in public law proceedings, we've got a different framework where we look at the relevance of allegations, and evidential output is a consideration. So on paper, is the complaining party going to be able to discharge their, burden of proof? And I think in private law, that's something that is overlooked. But if there was some, again, I'm sort of playing ping pong a little bit with myself, because I know judges wouldn't want to necessarily have summary determinations on allegations. But I think a judge can, under case management powers, take an overview and determine that there's, a limited prospect of success of that allegation being proved, and then making decisions about what happens next for a case, rather than what we still sometimes see is, well, we'll just have to go through the motions to sort of close it off so it doesn't resurrect itself again, or because a judge doesn't have the time to necessarily undertake that analytical exercise at a case management hearing. So I think if it was front loaded in terms of judicial consideration and decision making, you'd probably see a reduction in fact finds, and would be my forecasting. But whether that's going to be something that is encouraged by way of change, or whether people think it is a good idea, I don't know. But I think that would be my food for thought on that question.
Yeah,
I agree. I think delay is a big issue with fact finds, and like you say, maybe it's directed for a Section 7, that might be 12 to 16 weeks. Then that recommends that there's a fact find hearing, and we're already 4 months down the line potentially, so it needs to be clear early on what the court's decision is on whether a fact-find hearing is necessary or not, and if it is necessary, getting those directions in as soon as possible.
Yeah. I think the biggest change, well, I mean, it's something that the family courts have to strive for, and they should be doing it, but I don't see happening a lot, is judicial continuity. I don't really come across many private law cases nowadays which tend to have that level of continuity that it needs, and I think it's very critical for a family, for the lawyers in the court to get to grips with it, to be honest, especially when you have a situation where, you know, you might go through different judges and they might have different, you know, listings, they might have block lists and stuff like that. So having someone as a judge who's continuously been involved in the case really helps with that exercise, because even if that judge does have a busy list on that day, they've already gotten to grips with the case, they already know the family, and so you can have, you know, quicker and better decisions being made in terms of those cases.
I agree.
All right. Well, I think we'll leave it there. And thank you both for joining in. And thank you all for listening to our podcast. You can find us on Spotify, where you can like and subscribe. And also our podcast will be available on our social media channels. Thanks for listening. Thanks to you both for joining, and goodbye.
Thanks, Amjad.
Thanks, Amjad.